This heartless teenager trapped a family, robbed them, and the judge was determined to ensure she faced the consequences.
But the point of the matter is that she was in the car and not actively terrorizing these people. I make that distinction, but I also understand that if she's there, that she's a part of it.
All right, because I'm reading the reading the stipulations, and the stipulations, it says that she was the one who boxed the driver in.
The situation here is that they specifically targeted a mother and a young child. That child's been damaged for the rest of his life. He's gone through immense trauma, and the role that Ms. Johnson played here was an important one. She boxed them in. She's the reason why they could not get away.
Your problem is sometimes when you've done something that is considered so horrendous, right? No matter the changes you've made, sometimes it's just a prison offense. In the stipulations, the driver of the vehicle said, hey, my son is in the car. And that didn't give anybody pause. Everybody just still continued with what they were going to do. That's a problem for the court. And I'm going to sentence you to 6 years in the prison. All right. Court is calling 2023 CR 3848, State of Texas versus Michaela Elise Johnson. Can I have parties announced for the record for the state? Defense?
Patrick Hancock for the defendant.
All right. And are you Ms. Johnson?
Yes, ma'am.
All right. We're here for sentencing. You entered a plea of no contest to robbery on December 4th. According to the plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. The state is opposing your application for community supervision or deferred adjudication. They're taking certain items into consideration. All right. Did you all have a chance to review the PSI report, state?
Yes, Judge.
Defense?
I did, Your Honor.
Any objections to the PSI report, state?
No.
Defense?
No, ma'am.
All right. State, any witnesses?
No, Your Honor.
Defense, any witnesses?
Yes, Your Honor, I do. I have Miss Alicia Franklin, Michaela's mom.
All right, Ms. Franklin? Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, that nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Make sure you keep your voice up so the court reporter can hear. If you can state your name for the record.
Alicia Franklin.
All right, defense.
Miss Franklin, good morning.
Good morning.
You and I have spent a lot of time together regarding Michaela, is that correct?
Correct.
And you are aware that Michaela has accepted responsibility for a robbery here in Brick County.
Correct.
And today is the day that the judge can either send her to prison or entertain her application for probation or deferred adjudication.
Correct.
Ms. Franklin, let me just ask you, how old is Michaela?
As of now, she is 18. When the case started, she was 17.
And when did she turn 18?
November 3rd.
And where is she a student at?
At Roosevelt High School.
What grade is she in?
She's a senior.
And being in Roosevelt High School, has she made future plans, applied to any universities, or done anything at this point in her senior year?
Yes, she was accepted to UTSA, and we're pending.
Excuse me, please whisper.
Say it again, ma'am.
She was accepted to UTSA, and we're pending the application for Clark Atlanta University.
Very good. And how is she doing in school?
She's doing good. She's on my honor roll. Right now she has all A's and perfect attendance since she's been out.
And did Michaela request a letter from one of her school counselors to offer to the court today?
She did.
John, I tendered this to the state for their review. At some point, you'd like me to look at that, Judge.
All right, any objections to the court reviewing this? All right, you may continue.
Ms. Franklin, with regard to that letter, is it a positive review of how Michaela's doing at Roosevelt High School right now?
It is. Michaela's right now, since her release, she's at the best she's ever been. She's focused, she's serious about furthering her future for college, and she's on the right path.
I'd like to take you back to, I guess, the time around this offense. And before I do that, I want to ask you, are you a single mom?
I am.
Does Michaela have a father in her life who's active, or?
He's not active, not consistently.
And does she have any siblings?
She does. She has a brother and a sister from her father.
But living in your household is
No,
just you?
no one, just me and Michaela.
I want to take you back to around the time of the offense. Do you remember getting a call that Michaela had been locked up for some very serious offenses?
Yes, I do.
And can you tell the court what your response was?
That she needed to sit there. I left her in there. She needed to understand what she had done and take responsibility. I left her in there for 5 months before I bonded her out, so she could understand that she didn't do anything, it wasn't something small. She needed to understand exactly what she did and what she could look forward to. She needed to know what prison or their county was, what jail was.
And do you think those 5 months had a significant impact in her life?
Most definitely. I know for a fact she doesn't want to go back. She definitely has a true meaning of what jail is.
And was that your goal at that time?
That's definitely was my goal, because I could have bonded her out the same day or the next day. I mean, I could have got the financial means to get her out. So it was definitely my goal for her to learn her lesson. And hopefully we don't ever have to revisit this again, which I don't think we will. I honestly think that she did learn her lesson.
Miss Franklin, let me ask you, at the time when she was arrested, were there some behavioral problems that you picked up on?
Yeah, there was, but I thought she was just being a rebellious teenager. I didn't realize she was like depressed and had low self-esteem until she has thoughts. I took her to Little Ridge, but they let her out and she did a little counseling here and there. So I thought she was just being more rebellious to herself. I honestly didn't know it was mental health issues there. But once I did know, I've gotten her help.
What mental health issues have you discovered regarding your case?
Definitely depression, low self-esteem. We've been going through exercises with the counseling sessions. And me, myself, just trying to boost her up and get her on the right path to feel good about herself.
And do you think you're on a positive path right now?
Most definitely we are.
She's back living at home?
She lives at home. Our relationship is really good. She's more open. We actually have conversations about how she's feeling. And I think we're on a really good path.
And that's different than what it was before the
Most definitely. She would stay to herself more, lock herself up in her room. Just for me, what I thought was normal teenage stuff, but evidently it was a little deeper than that.
Ms. Franklin, you own a business. Would you tell the judge what you do for a living?
I do. I'm Sugar Glamour Salon, a hair salon in San Antonio.
And have you and Michaela talked about her interest in working in the salon?
Yes, but actually before this she did. She was my assistant. And to be honest, I need her back as an assistant, but she wants to be a barber and to get her through college. It'll be something for her to fall back on. And I can, I'm also an instructor, so she can get some of her hours through me.
You mentioned that she's been accepted to UTSA.
Yes, she's been accepted to UTSA, but she's also, we're pending the application for Clark Atlanta, which she preferably would want to go.
And what would be her interest in studying in college?
Business marketing.
So you left her in jail for 5 months and now she's been on pre-trial release as a condition of her bond.
Correct.
I know we had one GPS circumstance that we had to take up with the court. But
Yes.
other than that issue that was straightened out here in the courtroom, do you think she's been compliant with all the rules?
Yes, she's been compliant, and I also make sure she's compliant. I mean, we get home on time, way before time. We don't take no shortcuts. So yeah, she's definitely compliant.
I know that today we had the opportunity, the three of us, you, me, and Michaela, to go through the pre-sentence report. You can see there are some pretty raw feelings on the part of the listed complainant.
Yes.
Can you tell me if you think, even before today, do you think Michaela recognizes just how serious this offense was and the fear that people were placed in and the after effects of that fear.
Yes, she definitely recognizes that. She's definitely voiced how remorseful she is for this. I know for Christmas we did. She wasn't able to actually go to the battered women's shelter, but she did produce a toy drive. So where she marketed it, and we received a lot of toys. I think over 500, and took it back to the battered women's shelter. She definitely is remorseful, and she definitely understands that she put these people in fear, and it's not to be taken lightly.
Very good. Could you address very quickly whether you think your daughter would be a good candidate for probation or deferred adjudication in this court?
I think she would be a great candidate. I think, matter of fact, I know she has a bright future. This was something that she got herself into that I know she regrets. And I don't think that she should be sent to jail. She's done 5 months, and I understand that it's not the same as 10 years, but she definitely recognizes and has had a taste of what jail is, to not do this again and not be in any more trouble, and to succeed and hopefully help other juveniles and help other people who are going in that direction.
Ma'am, that's all the questions I have. The state has an opportunity to ask any questions they want.
Yes.
Any questions?
Were you aware that this offense occurred on February 8th of 2023?
Once I got a call from the Michaela when she was already in custody.
So you knew the date.
Yes,
And what day was that of the week? Do you remember?
I do not.
Would it surprise you that it was Wednesday?
I mean, I don't know.
It was a Wednesday.
Yeah.
Would it surprise you that this offense occurred shortly before 1 p.m.?
The whole thing surprised me.
But I'm asking specifically about the time at which the offense occurred. Would that surprise you? Did you know that it happened?
I did know. I mean, I've known since by reading the papers, and
Where should Michaela have been?
she should have been at school.
So, do you know, or did Michaela ever talk to you about what happened during this offense?
Yes,
So you were aware that the victims in this case was a mother and her young 4-year-old son.
yes, sir.
And you had a chance to read the victim impact statement.
Yes, sir.
And did it shock you that this had a drastic effect on that family?
No, sir. I definitely understand the turpitude of the case.
So you understand what the victim's feeling when she's saying that prison would be appropriate here.
I don't think it would be appropriate for Michaela
and ma'am,
for the simple fact.
I'm going to ask if you could answer my question. Would it surprise you or does it shock you that the victim in this case is asking for prison?
No, sir.
Is it understandable?
It definitely is understandable.
And were you aware that the other two people that participated in this act, that they were both younger than you?
Yeah.
So she was the oldest one out of the group, right?
Okay. Yes.
So she should have been able to make better decisions than the other two, correct?
I don't agree with that. The other two had been in trouble. I understand. And she also was the only girl. So,
And specifically her role in this act, were you aware that she was the person that drove the car that boxed in the victim and her son?
I understand that she was the driver. Yes, sir.
Specifically that boxed in the victim and
I
her son.
understand.
Nothing else to say.
All right, any other questions?
Ms. Franklin, I think I tendered it to the judge as a part of the other letter, but we did take Michaela to be evaluated by Mark Harris.
I did.
He's a licensed therapist, is that correct?
Yes.
Judge, if I didn't give you that.
Yes, you did, and I reviewed it.
Okay.
It's
very good.
attached to that.
Thank you, Judge. And you had the opportunity to look at his assessment, and that's helped you on a path of understanding her now, is that correct?
Yes, it did.
All right. Thank you.
Thank you for coming in. All right, defense, call your next witness.
Judge, that's it.
All right, did your client wish to say anything?
Judge, I think I'm going to speak for her.
All right, so I want to let the parties know that part of my question, or maybe you can address this, counsel,
Yes, ma'am.
because it says that she is minimizing her role. And it says regarding the instant offense, the defendant stated, I have no comment at this, which I understand.
Sure.
But then she comes back and she does make a comment. And it says the defendant later stated, I feel it needs to be looked into more rather than what they are saying.
And I think we addressed that actually this morning, Judge. I think her point on that is she was charged with aggravated robbery. She did not possess, hold, or yield a gun. And so it's been kind of a process of explaining that to her. So I think that she's not minimizing her role as far as doing things with those young men. However, I think she's made a distinction that, contrary to what the state wants to put forward, is that she was not the leader of this. She was a follower in this, and she did not possess or hold a gun. So I think as to Miss Ballard's point in the PSI, maybe she could have gotten out of the car and said, hey, don't do that. She didn't do it. But the point of the matter is that she was in the car and not actively terrorizing these people. I make that distinction, but I also understand that if she's there, that she's a part of it.
All right, because I'm reading the PSI. I'm sorry, reading the stipulations. And the stipulations, it says that she was the one who boxed the driver in.
Well, Judge, we're here taking responsibility for the facts. So I don't think she has said that she's not guilty of this offense. I just think she has a different interpretation of her role versus those young men.
All right. Anything else from the state?
I was informed by our victim advocates that the witness on Zoom was dressed. It was a brown sweater. That's what she's saying that she was wearing.
No, the person who was on Samsung, that wasn't a brown sweater. Unless I'm colorblind or something's going on, they had on no top.
Well, all right, Judge, I just wanted to make sure.
All right, thank you. All right.
I don't want to overstep, but I do want to make a brief argument next time.
Yes, you may proceed.
So, Judge, when I first started representing this young lady, she was in jail. And as her mother said, usually I have to field those questions, how quickly can we get out of jail? I think Ms. Franklin took a very brave approach for a single mom, and that is that I want her to sit with. These are serious charges. I want her to get a taste of incarceration. I want her to understand that you have to be penalized or punished for the things that you do. So 5 months passed by, and so I think that the value in that here in the courtroom today is that she has a taste of incarceration. And I think she's come out of jail, Judge, and the letter from the Roosevelt High School from Ms. Howard says she's really doing well in school. It's hard for me to believe she's 17 years old when I met her and charged with such a serious crime, and she's turned 18 and she's only 3 months into her 18th year. So, Judge, it's one of those things. She's got a bright future. She's got hopefully acceptance into a school in Atlanta. She's been accepted to UTSA. Those letters, in my opinion, Judge, from Roosevelt High School, those are hard letters to get for the defense. And that's a really fine letter that supports Michaela in her application for probation. I don't want the court to think that she's minimizing this, because we've spent hours talking about the what ifs and how you can't find yourself in that situation. Her mom was bright enough through some talking that we had to get her sessions with Mark Harris. And Mr. Harris is very good through the juvenile probation and through private practice of bringing these young people in. Young people, he specializes in young offenders and working with them with this cognitive behavioral. You can't find yourself in the situation. You can't find yourself around the situation. If you do, then you need to leave. You don't need to be boxing anybody in cars. So I think this has been put square upon Michaela. I think she's done a great job out on bond. I think she's doing a great job in school right now. I can tell you that her relationship with her mother has never been better. I just really beg this court to give this young woman a chance. A conviction and being sent to prison is going to irreparably change her life. Now, I know that there's victims out there who have had their life irreparably changed too. There's nothing we can do about that. But this is a young lady who's clearly on a positive path, and we'd like for her to stay there with the court's permission.
State.
Judge, the situation here is that they specifically targeted a mother and a young child. That child's been damaged for the rest of his life. He's gone through immense trauma. And the role that Ms. Johnson played here was an important one. She boxed them in. She's the reason why they could not get away. I understand that she's made a lot of progress after the fact, but in that moment, she could have made different choices. Choices is what she's gonna have to make going forward. It's something that the state feels that prison would be appropriate here. The victims feel that prison would be appropriate here. That's what we're asking for.
Judge, I just want to, you see more of these PSIs than I do, but it looks like the juvenile offenders who I think want a more serious role in this. I can't read this correctly, but it looks like one of them had his cases dismissed, maybe placed on probation, and then one was sent to some kind of TYC placement. So I guess if I look at that, Judge, I just argue that there'll be some kind of equitable position here by the court to figure out what to do with Michaela. Again, Judge, deferred adjudication on second-degree felony is quite a good thing. I mean, we all know what deferred adjudication is, but sometimes it doesn't mean a do diddly damn in court. Here, it makes a big difference because it gives her a chance to prove herself, and it gives the court a long leash to make sure that she's doing well. I don't know what else we could bring the court to show that she's remorseful, doing well at home, doing well on her conditions of bond. So again, we would ask that the court wisely place her on deferred adjudication. Understand that she's done 5 hard months in the Bexar County Jail. I think she spoke about her fear of the jail with Mark Harris in that letter. I think her mom made a good decision, and we're hoping that will sway the court in giving her a chance at a future without being another young Black female with a conviction on her.
Here's the court's problem, and what I think people need to look at. Sometimes punishment, and all attorneys will tell you, when we're in law school, they tell you about the purposes of sentencing. Sometimes the purpose of sentence is for rehabilitation. Sometimes it's just punishment. Sometimes it's protecting the community. There are a whole host of reasons. But your problem is sometimes when you've done something that is considered so horrendous, right? No matter the changes you've made, sometimes it's just a prison offense. There are a lot of people who do things that I'm sure if they could go back in time, they would have changed it. They would have said, I wouldn't have done it. But the boxing of someone in with your vehicle, and I read the PSI report and I read the stipulations. In the stipulations, the driver of the vehicle said, hey, my son is in the car. And that didn't give anybody pause. I would think that there are certain things that should give people pause. For example, if somebody holds somebody at gunpoint and they want to steal their vehicle, they would say, oh my gosh, shucks, I didn't know there was a child in this car. Let me pause. But they gave nobody pause. Everybody just still continued with what they were going to do. That's a problem for the court. So this is what the court...
Isn't the problem that she was, no matter what her role was, it was still going to be something that was horrendous because it's a robbery.
Yeah.
So and I'm not trying to argue with the court, but under that circumstance, then then no one should be eligible for deferred adjudication.
Well, counsel, as you're aware, there are different types of robbery. And there are some robberies that don't involve a child. State?
Your Honor, so right here, one thing I did notice in the letter for the psychiatrist, something that is bothering Andrew, I've seen it somewhere in here, is that Ms. Johnson, she said she gave them a ride but did not know their intentions, but she played a role in boxing the men. She says that she had never had or handled a gun that night. When the police lit up her car, the boys threatened her if she didn't keep going. One of the boys threatened to shoot her if she stopped. Nowhere is that brought up in the report that she had mentioned that she had said that they had threatened her. So that's just something that is.
Well, I don't think it's her feeling, so it's not going to be in a police report.
Right,
but I can tell you that was her feeling on this. She did feel threatened by these two young juvenile offenders. But we're here today to take responsibility and not make excuses. So that's our answer to that, Judge.
All right. Is there anything else before the court makes its ruling?
No, Your Honor.
No, you're not.
All right, this is what the court is going to do. Court is going to find you guilty, taking consideration 2023 CR 3850, 2023 CR 3849, grand jury number 806632. There's to be restitution of $110 to John Bright in grand jury number 806632. Give you credit for any time served. I'm going to retain jurisdiction. Your attorney will tell you what that means, and I'm going to sentence you to 6 years in the prison. Did you review what it's entitled trial court certification with your attorney? Did you understand it, and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. And Mr. Hancock, you can explain to her what that means.
I will, Judge.
All right.
This fearless man uncovered the disturbing reality of treatment facilities and begged the judge for an opportunity to break free from the nightmare.
All right, so tell me what is going on at the Henderson facility.
I had a very successful 45-day call, but during that time, I made the decision to step away from the that I was affiliated with. They were doing fight nights. There were people out there still smoking too.
Fight nights?
Yeah, it was disrupted. The counselors would come in and they would read from a piece of paper for an hour and they would leave until the next day. And it was back to the same stuff. And I made it known that I didn't want no part of any of that anymore. I was trying to get back to my daughter, and a lot of people took that offense, and they threatened me and they were trying to jump me. And thankfully the guard was able to see that something was going on, and they pulled me out of the dorm that I was in, and they placed me in a single man cell in restrictive housing. And they said that by refusing that environment, I was refusing the program, but I'm trying to do better.
Okay. No, I appreciate that. Thank you so much for letting me know. So what I'll do then, you'll be transferred from the jail to lifetime recovery.